Good afternoon, students. Today, I want to discuss with you as to the questions that have been referred by our president and why these particular questions have been referred and what is Article 143, what does it provide under the Constitution, which leads to these questions that have been asked by our president. Now, we can't directly go into the questions that have been asked. However, after a reading of Article 143, we can do the same. I'll just share my screen. Okay. So, in the board, you can see that the first thing we need to understand is what is Article 143 of the Constitution. It states that if at any time it appears to the president, if it appears to the president that a question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it. He may refer the question to that court for consideration, and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. Now, let us break this part down. It means that the president, in relation to a question of law or fact, which it feels or which the president feels is of public importance, is of such nature that it is of public importance, and feels that it is expedient to obtain the opinion of the Supreme Court in such matter, then in such a situation, the president may refer this question for the opinion of the Supreme Court, for the consideration of the court. And the court may, in this situation, respond with their opinion to the whatever questions that have been asked by the president. So, in short, what this particular set of lines provides is the discretion to the president also in situations where they feel there is a question of law or fact which is of public importance to seek the opinion of the Supreme Court. And what one has to remember is that under these set of lines, the Supreme Court may or may not give its opinion on the matter, right? And this has what has been used by the our respected president at this point of time to refer her questions to the Supreme Court under these particular set of lines. Of course, there is an additional set which says that the president may, notwithstanding anything in the proviso of Article 131, refer disputes of any kind as provided under the said proviso to the Supreme Court for its opinion. The Supreme Court shall, in such situations, after such hearing as it thinks fit, report to the President its opinion. So, in this situation, there is a mandate because we can see that the terminology has shifted from the Supreme Court may to the Supreme Court shall. Right. So here we see that the Supreme Court may or may not give its opinion, but in this particular set of lines, it is expected to give its opinion. Of course, we are in relation to the first half, which states that you may, as the Supreme Court, as the terminology which has been used, the Supreme Court may or may not respond with its opinion on the question that has been referred to by the president. So now we are clear what is 143. It provides through the constitution the president the ability to refer certain questions, whether of law or fact, of public importance to the Supreme Court. This is a discretion with the president, and the Supreme Court has also a discretion as to whether they want to respond with their opinion on the matter or not. Now, coming back to what we are discussing, why did our president, why did President Murmu refer some questions to the Supreme Court? For this purpose, we need to go to the case of the state of Tamil Nadu versus the government of Tamil Nadu and another. Have provided the citation. So, Just having a basic outline of this case is important for us to understand why the questions have been asked by our president. Simply put, and because I want us to keep this brief, give you a quick outline, I'll give you the short version of what has happened. Now, in this situation, the governor of Tamil Nadu had 10 bills for his assent, had received 10 bills for his assent. Now, these had been repassed by the assembly without any modifications. Even in such scenario, the governor did not assent, nor did he return those bills. Rather, he reserved these bills for the president's consideration. Right. Now, what has happened in this situation, in simple terms, is that there is delay in regards to these bills, which have already been repassed by the um, assembly. And therefore, a question comes up at this point, which we must look into, is that um, is there a delay? Is this an administrative lapse in the context of so much time being taken for legislations which may be very important for that particular state? At this point, the state government had filed a writ petition regarding the status of those bills. Okay. Now, additionally, we must remember certain important provisions. Article 131, which gives Supreme Court exclusive jurisdiction to deal with disputes between the union and the state. Article 200, which outlines that the four courses of actions which are available to the governor when a bill is presented, which can be either assent, withholding assent, returning the bill, or reserving it for the president's consideration. Right? However, we see that this particular article does not provide for a timeline within which this action has to be taken by the governor. What happens with this is if there is a delay, we cannot really make any kind of comment on it because the provision is silent as to when it should be completed. There is not no clear timeline within which any of these actions must be completed or taken, and then this implies that in context of the fact that these bills, which could be means for justice for the particular state in this in regards to this particular case, are being consistently delayed. That could be one perspective that we are seeing. Right. So there is no timeline which Article 200 mentions. It gives four course of actions which the governor can take, which includes one, that is that the governor can reserve it for the consideration of the president, which is what happened with regards to these 10 bills. Now, another article which we must refer to at this point of time because it is relevant to the case is Article 201. This is basically in relation to bills reserved for consideration. I just wanted us to have an outline of it. It provides that when a bill is reserved by a governor for the consideration of the president shall declare either that he or she assents to the bill or that he withholds assents therefrom, implying that 201 is in relation to the president's role when a bill is reserved for his or her consideration. They have to assent or withhold assent therefrom, and additionally, there is more to the provision. Just wanted to give you that this speaks about the president's role, this speaks about the governor's role. No real timeline actually mentioned in 200, especially 131 talking about the Supreme Court's jurisdiction, and this was the incident which, or the set of facts, primarily in short, which led to the case of the state of Tamil Nadu versus the governor of Tamil Nadu. All right. Now, Article 142 also is relevant. This provides for the Supreme Court's power to enforce decrees and orders, which has been used in this particular case. It has exercised its right, its powers under Article 142 to enforce decrees and orders. Right. So now we are clear. 143, the discretion with the president to take the opinion of the Supreme Court, and the Supreme Court may or may not respond with its opinion in the sub-article 1. 131, exclusive jurisdiction of the Supreme Court to deal with matters relating to the state and the union. Article 200, governor's role in case of or the courses of action available to the governor when a bill is presented. 201 talks about when bill is reserved for consideration by the president. Article 142, enforcement of decree and orders by the Supreme Court, that particular power of the Supreme Court. Bearing now these important articles in mind, we look at some important parts of the judgment. This part states that we are of the considered view that although the option to refer a bill to this court under Article 143 may not be mandatory, yet the President, as a measure of prudence, ought to seek an opinion under the said provision in respect of bills that have been reserved for consideration of the President on grounds of perceived unconstitutionality. This is all the more necessary as there is no mechanism at the state level for the governor to refer bills to the constitutional courts for the advice or opinion thereupon. Under the scheme of the constitution as we see it, there is only one possible way for the governor to ascertain the palpable constitutionality of a bill, which is by way of reserving it for the consideration of the president, who in turn then is expected to invoke Article 143. In simple terms, what the Supreme Court tried to say in this para is that when there is a situation where a bill is reserved for consideration to the president, if it is in relation to matters of unconstitutionality, the prudent act would be to refer that matter or refer that aspect to the Supreme Court under Article 143. What this implies is that when matters are of constitutional nature involved in regards to bills that have been reserved for the consideration of the president, the judiciary is trying to say, or in this case, the Supreme Court is trying to say, they must be involved because they are interpreters of the constitution. They are constitutional courts. So, stating that they must be looped into the matter under 143 to assess whether constitutionality or unconstitutionally is present in it. So, the para hints at the fact that the judiciary wants to, through an Article 143, delve into whether the bill which is reserved for consideration is having a constitutional or an unconstitutional aspect. Now, the next para. What emerges from the above is that the fine but pertinent distinction between the time limits that are expressly prescribed and those that are judicially evolved is only that in the former, the consequence of deemed dissent emanates from the provision itself, whereas in the latter, there could be no such consequence except to the extent that the courts judicially reviewing the action or inaction can direct a decision to be taken within a time bound manner, or in exceptional cases like the one at hand, deem the assent to have been granted under Article 142 of the Constitution, which we shall discuss in the later parts. Now, this is again an interesting part which must be looked into. As I told you, Article 200 doesn't provide for a clear timeline within which the governor must act. Now, here you see that the language emanates, and this particular decision did provide for a guideline of what timeline must be followed by a governor. Okay, so this decision tried to incorporate and has incorporated a type of timeline, right, which must be followed. And here the Supreme Court is explaining, in case the timeline which was not there in the constitutional provision and which has been added or judicially evolved, what will take place. And it has mentioned here that in such a situation, an assessment will be made that why the timeline which the judiciary provided was not complied with. And in those circumstances, if it deems fit, in exceptional cases, like what happened in this case, it may give deemed assent to those particular bills that have not been assented to. And this will be done by using the power of the Supreme Court under 142 of the Constitution. Now, this too is an important aspect in which the judiciary has entered into, one can say. I'm just simplifying this for us. What has happened is now the judiciary is saying there is no timeline. We will introduce a timeline. If the timeline is not complied with, we will make an assessment, and in exceptional cases, if we feel it is so required, an assent will be deemed to have been given in such situations by using Article 142 of the Constitution. And the reason why this is a very important para is that it leads to this question. In situations of deemed assent, what has happened in this particular case, they've become the first acts of any legislature in India to have taken effect without the signature of the governor or president, but on the strength of a judgment of the Supreme Court. Do you understand, students, what has taken place? These become, as has been mentioned in the last half, in context of these acts and legislatures, they are the ones which have come through deemed assent through the concept which I just explained here, rather than the signature of the governor or president. Right? Now, the idea of giving these two paras is to explain to you that the tonality of the decision, the judgment, is that the judiciary in certain situations should be, will be, in context of 142, the idea was that 142 is a power which will be exercised, and deemed assent will be given in situations where an assessment is made and the timeline has not been followed, and therefore those legislations would then come into power, and in this case have come into power without even the signature of the governor of the president. Thus, the role of the governor of president and the fact that a judgment could also bring a legislation into effect is an important question that you and me must look into or think into, right? When we talk of separation of powers with different roles to different branches of our government, when we talk of this aspect, it is something which we must look into cautiously with lot of bearing, whether it is a good or a bad move, which is something which is personal to our perspectives on the matter, right? So, repeating myself, first para, here the court is saying 143, even though it is not mandatory, the first half is not mandatory. This discretion is available. The president, in situations where there is a constitutional aspect involved, must refer to the Supreme Court. That's what the Supreme Court has mentioned here. And here it says that 142 gives certain powers to the Supreme Court, and they can be exercised in context of giving a deeming assent in regards to certain situations where timelines have not been followed in with regards to bills that have been reserved for consideration and so on. In such situations, as an example, one can say the court is trying to say that through a judgment, effect can be given into legislatures, right? Now let us look in with this short background what questions has our president asked. First, what are the constitutional options before a governor when a bill is presented to him under Article 200 of Constitution of India? Is the governor bound by the aid and advice of Council of Ministers while exercising all options available with him when a bill is presented before him under Article 200 of the Constitution of India? is the exercise of constitutional discretion by the governor under Article 300 of the Constitution of India justiciable, which means that can it be questioned, can it be brought before a court of justice? Can Article 300, a constitutional, an article which is providing constitutional discretion to the governor, vulnerable to a court of justice? Second, fourth, Article 361 of the Constitution of India, is it an absolute bar to the judicial review in relation to actions of a governor under Article 200 of the Constitution of India? So, does 361 create a bar on judicial review to anything in relation to Article 200 of the Constitution, which provides for the actions of a governor? In the absence of a constitutionally prescribed time limit and manner of exercise of powers of the governor, can timelines be imposed and the manner of exercise be prescribed through judicial orders for the exercise of all powers and under Article 200 of the Constitution of India by the governor? So, this, as we had just discussed, it shows like a direct reflection to the judgment that we were talking about. Repeating myself here, in the absence of constitutionally prescribed time limits and the manner of exercise of powers by the governor, can timelines be imposed and the manner of exercise be prescribed through judicial orders for the exercise of all powers under the Article 200 of the Constitution by the governor, right? Is the exercise of constitutional discretion by the president under Article 201 of the Constitution justiciable? Again, which implies that can it be brought before a court of justice? Can it be, can it come and become vulnerable to a court of justice? Can this particular power or discretion which we talk about under the constitution be vulnerable in front of a court of justice or be assessed in front of a court of justice, right? In the absence of a constitutionally prescribed timeline and the manner of exercise of powers by the president, can timelines be imposed and the manner of exercise be prescribed through judicial orders for the exercise of discretion by the president under Article 201 of the Constitution of India? So we see that a similar question was previously asked in context of Article 200. The same question has been asked with regards to the discretion of the president under Article 201 of the Constitution. Then, in light of the constitutional scheme governing the powers of the president, is the president required to seek advice of the Supreme Court by way of a reference under 143 of the Constitution of India and take the opinion of the Supreme Court when the governor reserves a bill for the president's assent or otherwise? Now you see that this was a comment that we saw here, right? This is what has been advised by the court to be done. And here you see that this has been questioned by our respected president, honorable president, right? Are the decisions of the governor and the president under Article 200 and 201 of the Constitution of India respectively justiciable at a stage anterior into the law coming into force? Is it permissible for the courts to undertake judicial adjudication over the contents of a bill in any manner before it becomes a law? So, again, a question is being asked by the president in context of the role of judiciary, where it is in context of something which is in relation to a bill and it has not yet become a law, right? And this is in light of Article 200 and 201, right, which provides discretion to both the governor and the president in certain matters, right, as we have discussed previously. Can the exercise of constitutional powers and the orders by the president governor be substituted in any manner under Article 142 of the Constitution of India? So, whatever has been entailed as the acts of the president or governor, can it be substituted by Article 142? And at this point, I want us to go back to this, and I want you, if you want, you can pause at this and read this again. The Supreme Court here has said that 142 will allow them to do something which is in relation to um, acts which were limited to, one could say, in simple terms, to the president or governor. Repeating this question now again, can the exercise of constitutional powers and the orders of by the president governor be substituted in any manner by under Article 142? Again questioning, can Supreme Court come here? Is a law made by the state legislature a law enforced without the assent of the governor, granted under Article 200 of the Constitution of India? So, where there are legislatures or legislations which are coming in without the assent of the governor, can they be something considered to be in force? So, again, the question is hinting towards, can anything which was expected constitutionally to have a certain procedure to be followed in context of a legislation coming into force remain the same when the required procedural mandate has been removed, right? In view of the proviso to Article 145(3) of the Constitution of India, is it not mandatory for any bench of this Honorable Court to first decide as to whether the question involved in the proceedings before it is of such a nature which involves substantial questions of law as to the interpretation of Constitution, and to refer it to a bench of minimum 5 judges? Again, discussing that when a decision in relation to substantial questions of law as to the interpretation of constitution are involved, it must be a minimum bench of 5 judges that should be involved, is the question which our president has put forth, right? Now, in the decision that we are referring to, where lot of comments on constitutional aspects have been given, this was this a judge? Was this a bench which included 5 judges minimum? No, right? Do the powers of the Supreme Court under Article 142 of the Constitution of India, limited to matters of procedural law, or Article 142 of the Constitution of India extends to issuing directions, passing orders which are contrary to or inconsistent with existing substantive or procedural provisions of the Constitution or law in force? Lastly, the question asked is, does the Constitution bar any other jurisdiction of the Supreme Court to resolve disputes between union government and the state government except by way of a suit under Article 131 of the Constitution of India? What my idea of this particular video was to explain to you the connection between how 143 provides for the president to seek advice from the Supreme Court, seek opinion of the Supreme Court, which now it is seeking in order to understand the role of the judiciary itself, right, in situations which have arisen after the decision which has been passed by the state of the in the case of state of Tamil Nadu versus the governor of Tamil Nadu and another. So we can now see what 143 provides. We can now see the background and some important paras which give a lot of hints as to what may be something which is creating debate in the roles of the judiciary in such matters. which have now been taken forward by the respected president in these 14 questions. I hope, students, I have been able to give you some line of thought as to why these questions have been referred by our president, what is Article 143, and a short outline of what really happened in this particular case, which may have led to most of the questions that have been asked uh, in the set of questions that have been referred by our president. In case of any queries, students, please put it on the comments. In my next video, I'll definitely try to answer them. In case of any questions in relation to my PYQ series, I will answer those questions in my next PYQ video. Thank you so much, students, and all of the audience which are watching this video. Have a great day.